Good evening and welcome to this session of the my first session, I should say, of the live virtual classes conducted by the Board of Studies of the Institute of Chartered Accountants of India. My name is Srikanth, Chartered Accountant, and I will be handling a portion of this subject, Corporate and Other Laws. Today, we are going to start on chapter 2, which is Incorporation of Company and Matters Incidental thereto. It's quite a long topic and basic topic. So we'll be covering it. Some of you may be having the institute material in front of you, trying to, study along with that. It's a good idea. But I suggest that, don't do that continuously because you will not get benefits. My suggestion, what all I'm covering will be there in the material. Whatever is there in the material will be covered. Okay, don't do the auditing, continuous auditing. Don't worry. This is 3 sessions. So any doubt you have, you can ask me anytime. Suggestion, keep the material. But don't keep on comparing what I'm taking, where is it, which page. Don't do that. This is not a high school, professional, intermediate level. So don't worry about that. Aram say just listen to what I'm saying. Take in the subject. Understand the subject. And you will first understand. Thereafter, you read it on your own and you will easily understand it. So, not like 5th standard or 6th standard class where, you have to which chapter it is. Basically, in chapter 2, but sometimes for making the topic easy, I would have, to make it a little more logical, I would have sort of mixed matched the topic. So, some will come front, some will go later. So exactly, you may not be able to, you may not be following that. By and large, I will follow the same route only, don't worry. So my humble request, because earlier batches I found many students get excited when they say which page, which I can't tell you because I don't have the material with me here. But for preparing this PowerPoint, material has been fully consulted and then only I have done. The entire ICAI material, I have read it and I have incorporated it in my PowerPoint. This PowerPoint will be shared by me, if not today, tomorrow on the portal. Complete PowerPoint will come to you. In case I make any changes, I'll again maybe upload it. I used to avoid uploading. Today I will upload it. Now, so let's begin. Basically, a company, you've already gone through the basic concept of a company, etc., etc. So, but now we are going to talk about incorporation. So, as you are aware, a company is a separate legal entity distinct from its members, right? It has perpetual succession and can be formed only for a lawful purpose, right? So, the company is a legal person. So, created by law. You and I are natural person. We are created by a process of biology, right? So we are biological creatures, persons, whereas natural biological persons, organic. Okay, we live, we grow, we are born, we grow, we live, we die. Company is a legal person. It's created by a process of law. This process of creating a company or bringing a company into existence is called incorporation. This is the, shall we say, legal process, and therefore everything has to be done as per law, right? We have to comply with the requirements of law. So in this topic, we will see what are the procedure to be followed for incorporating a company. Also, we will see other related topics, right? And some basic concepts which would help you to understand and appreciate future topics that we will be covering as we go. Who does this? A company doesn't come into existence spontaneously. It does not suddenly, unlike, some places when the rain falls because of the seeds being spread by the birds, okay? The birds eat and they throw the seed. No, they eat the fruit and the seed is kept out, sent out. That seed will be waiting. when the rain falls, it will germinate and it will grow into a tree plant. That's how forests are created, okay, in nature. But a company cannot come into existence like that. It is done by a conscious process. It is done by people who want to have a company. Why? For the purpose of raising funds, investing, using that money to run a business, earning profit, and repaying to themselves as dividend and their share price going up. That's it. So, who is interested in doing it? There are some people initially who want to do it. They are called promoter. So they conceive the idea. They think there is a need in the environment for this. Therefore, let us satisfy that demand for which let us manufacture the product. So for that, with that for that objective, they form a company. Are you able to understand? These people are called promoters. Later on, when you come to prospectors, it's an important topic. Later, possibly the next topic, you will definitely understand the importance of a promoter. See, the promoter is not defined in the Companies Act. I've described a promoter, a person who conceives the idea, who forms the company, collects the money from the public, etc., is called a promoter. That is not given in Companies Act. This is a general definition of promoter and general dictionary definition of promoter. But under the Companies Act, they are very clear. Who is promoter? A person who has been named as such in a prospectus. So his name is mentioned in the prospectus. Or in the annual return of the company, who are the promoters? Clearly the name is given. For example, in the Tata Group, there are many companies. So the promoters are the main Tata company, Tata Sons, or like that. So that will be called promoter. TVS Group, it's a promoter. So they will form a new company for a special business, but they will be the promoter. A promoter is also a person who has control. It's a very powerful word. Since for some of you, not all, most of you would have been exposed to the basics of company law in some form or the other, right? But even for them, this word is a very powerful word. Control. Anyone who has control over the affairs of the company in any way, whether directly or indirectly, whether a shareholder, director, or otherwise, is a promoter. A simple example, practical example. Mr. A is a very big shot, but he doesn't want his name to appear anywhere in connection with the company for some reason. He calls his employees, means people who work with him or under him in any company, etc. He makes them the directors. In a way, he nominates them. They become his nominee. He says, you guys go, you form that company and you become the directors. Now, so these two employees will come and become director now. Still, who is having the control over the affairs? The gentleman only. Because these two people are nominee. They are employee. They will simply do whatever this fellow says. Are you able to understand? This is a very, very, shall we say, implied method. It is not direct. It is indirect. Let us see proved. See, but still, such a person, he is not named in the prospectus. He is not coming anywhere in the records, but still he has control. When he calls, these two guys do it. So this type of things will happen only in investigation. When the company is finally being investigated for fraud or something, they will catch hold of these directors and who are you? Where is your money? Where did you get? No, sir. I don't know anything. Everything Saab only told I did it. So that man becomes the promoter who has control over the affairs of the company, directly or indirectly, whether as a shareholder, director, or otherwise. This otherwise is also a very powerful word, very wide. See, they described two categories, shareholder, director. Then they say otherwise. Therefore, anything that is not covered in shareholder, director will automatically come under otherwise, which means that everything is covered. Are you able to understand? If only in the mythological tale of Narsimha, Hiranyakasipu was a fool. He was saying A or B, he neither in the air nor in the ground, neither inside nor outside, neither in the morning nor in the night. So he was always giving dualities. But if only he had added one more word, neither by day, nor by night, nor otherwise, then it would have been really difficult to still, because otherwise would have covered every option other than day and night. So legally, it's a very powerful. But that, of course, the Maya is such that he couldn't think of it. So he said neither here nor there. Therefore, when Narsimha came, he said neither inside nor outside. Therefore, on the doorstep, partly inside, partly outside, like that. Neither on the air or on the ground. So half of it on the lap, half his feet on the ground. So everywhere loophole was there. But once you put the word otherwise, the loophole is gone. You're plugging the loophole. Even other categories are covered in that otherwise. It is an omnibus, or we call it as this type of a definition would become exhaustive. Everything is covered in that. In accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. This is another example. So very similar to what I told now. In my example, same D also is covered now. I am A. I am not named anywhere, but two people are directors, board of directors. Both the guys are my employees. They will do when I come into the room, they will stand up and salute. So that is, they will have to take my advice, directions, or instructions. So, but one exception, a person who is acting merely in a professional capacity, for example, a chartered accountant, a solicitor, a banker, after all, the directors would act according. See, if I advise the directors, they will act. But I'm advising them not on the business, but in a professional capacity. So I will not be a promoter. I use the word I because I am a practicing chartered accountant. Therefore, sometimes when I teach, especially inshallah, if you are able to teach, if we continue and I'm able to handle more of these sessions and I teach accounting or auditing, you will find me frequently using the word I in the context of the managing partner of a firm of chartered accountants. And I will use that experience to share knowledge with you. Kindly don't mistake me, but though I'm sure you won't. But so you should not think why he's saying I like that. It's not ego. It's only sharing my own personal experience of 35 years of practice as a chartered accountant. Now I'm going to complete 37 years of practice. 1987, I qualified as a chartered accountant, started practicing. COP holder from 1987. So sometimes when I use the word I, it means me as a chartered accountant in practice. Any relation example from corporate side also, I'll give it. Don't do it. You as a CFO of a company also, I'll tell how it will impact you. You as a GM finance of a company, how it will impact you. This law is a very, very important law for chartered accountants. You cannot afford not to know it. Because if you are going to be employed in the finance department of a company, you will be exposed to this law completely. You will have to be expert in it. So kindly do not think that this is an ancillary subject. It's very much as important as taxation or auditing, etc. So the official definition is meant for identifying the persons to be punished in case of misstatement in prospectus. It does not truly describe a promoter. So that's what I did earlier. See, he is the person who conceives the idea and he undertakes the process of incorporation. Right? Yeah. So belatedly, I greet Soumya. So she is glad to see me. I thank you, madam. I hope we'll have a good session going forward. See, there is something called a query pad, which Soumya has accessed. My humble request is put your queries in the query pad rather than in the chat box. Reason, I may not be able to see the chat box during the session. Whereas the query pad is open in front of me on my mobile and it is there in front of me. So it will be easier for me to see your query on the query pad rather than in the chat box. And what I will do is, at some logical point, I will stop. I will go to the chat box and see if any queries are there and I will answer. Now, a promoter cannot be called an agent since the principle has not come into existence, Baba. Suppose there should be an agent, there should be a principal. Now, at the time when the promoter is incorporating the company has not come into existence. So, he cannot be an agent of a non-existent principal. Friends, you are all expert in contract act. I don't know how to tell you. I can be an agent of an undisclosed principal. No problem. So long as I inform you that there is a principal on whose behalf I am acting, act will be binding on the undisclosed principal and not me. But I cannot be an agent for a non-existent principal. Nor can that principal, after coming into existence, ratify. Because at the time when the act was done, he was not present, which is why any pre-incorporation contract entered into before incorporation, if you do something so-called on behalf of the company, it cannot be because you are not an agent. It is not binding on the company. Pre-incorporation contracts are not binding on the company. Right. Post-incorporation, what the board should do in the first board meeting, they should pass a resolution, not ratifying, but accepting. There's a big difference. It cannot be ratified. But what the company will do on incorporation is say, these contracts were entered into before the formation of the company. Now, the company is taking it. It's almost a novation. So the third party should be informed. Going forward, the contract obligations under the contract, all benefits will be transferred to the company. So it is almost like an assignment of the contract or novation. There is no ratification. Similarly, he cannot be a servant because there is no master at the time when the incorporation is going on. A promoter cannot be called as a trustee. Why? Because trustee cannot sell his own property to the trust. He cannot make a profit. A trustee cannot sell to the trust and make a profit. But a promoter can sell his property or business to the company which he promotes. Many cases of these are promoter cheating companies when they sell their property. They can't do that. That will be a crime. For example, see this, what happened here. There's a fellow called Erlanger. Erlanger was the head of a syndicate. The syndicate purchased an island in the West Indies, which contained valuable mines of phosphates. Those days, the phosphates were very important. Today, everywhere phosphates are being manufactured. In those days, phosphates are very important for as fertilizer and all. So, the purchase price was 55,000 rupees. Erlanger, he is Erlanger. He formed a company to buy this island. A nominee of the syndicate, contracted to sell the island to the company for 1,10,000. Are you able to see the point? See, the Erlanger got it for 55K. Now, instead of disclosing himself, he puts a nominee, X, on behalf of the syndicate. Syndicate means group of people having a common objective. So, together they located an island. They purchased it for 55. Then they formed this company and nominated X to sell the island to the company. So on behalf of as an agent of the syndicate, X sold it to the company at 1,10,000. Company has been formed and third parties have invested money. It was held that since there was no disclosure of profits made by E and the syndicate, the company was entitled to rescind the contract and recover the purchase money from E. Please note, the crime of Erlanger was not to make a profit. Erlanger and the syndicate have made double, 55. There's nothing wrong. If you want to do it, you do it. But it has to be disclosed to an independent board. Are you able to understand? Erlanger forms the company, then there should be an independent board to whom Erlanger and the syndicate should say, we want to sell this 1,10,000. We got it for, since they are promoters, they have a fiduciary relationship to the company. They have to inform at what price they are selling. So this was the famous case, Erlanger versus New Sombrero Phosphate Company. To be a promoter, one need not necessarily be associated with the initial formation. Anybody who subsequently helped to arrange floating of its capital. That is why they say a person whose name is mentioned in the prospectus is also a promoter. This was decided in a case, Lagunas Nitrate Company versus Lagunas Syndicate, right? So, quickly, you've already seen types of companies in definitions. Here we'll see some of the broader categories. So we have registered companies. So we have two types of companies, an incorporated company and an unincorporated company. Incorporated company, basically, there are three categories. One is registered company. 95% companies are registered under some law or the other. Every country has a law under which companies are incorporated. Every country, in fact, in the United States of America, every state has a law under which company can be formed in that state. So there are statutes, rules, something, some method, some format is there for forming a company, incorporating a company with, shall we say, separate legal entity, common seal, like perpetual succession, right? Statutory companies, you might find, also are there all over the world. In India, the government of India, as part of its efforts to bring about economic development in those days, has formed many companies by act of parliament. For example, the State Bank of India was brought into existence by an act of parliament. The State Bank of India, the LIC, act of parliament. IDPI, act of parliament. The industrial development. Later on, they wanted to access public money. So these banks converted themselves into companies coming under the Companies Act in those days, 56. Now, 2013. LIC recently converted itself into a company under the 2013 Act in order to access public funds by going for an IPO. The Life Insurance Corporation of India Limited. Before that, it was Life Insurance Corporation. See, the Indian Oil Corporation, IOC, later on became IOCL, Indian Oil Corporation Limited. So to begin with, it was a statutory company with limited liability, etc. Brought into existence by a statute, act of parliament. Thereafter, they decided to opt to go under the Companies Act with all the concomitant duties and obligations. Slowly, the government of India, as part of its larger scheme of privatization, has disinvested in many of these companies through market route. They have offloaded their shares. So there is statutory. In England and certain other countries where there is a king or a queen, we have chartered companies where the king or queen gives the charter. For example, the first ever company is a chartered company. We'll come to that. So under registered companies, see, unincorporated companies, basically, under the Companies Act, a firm can get itself registered and get itself liquidated under the Companies Act. That's all. Otherwise, there's nothing, no big deal. Don't waste your time on this. Under registered companies, we have private, including OPC, which you will be seeing today. OPC, one person company. You have a private company or a public company, again, limited by shares, limited by guarantee, or unlimited. Okay, both private or public can be limited by shares, limited by guarantee, or unlimited. Unlimited companies are, see, in those days, under the 1956 Act, there were a few unlimited companies whose liability of a company is never limited. Hello, liability of a company is always unlimited. It is the members' liability which is limited. Liability of the members of a company is limited. Okay, to the amount, if any, unpaid on the shares. Later on, if somebody will teach you share capital or me, we will tell you. So limitation of liability is not for the company. That means whatever assets the company has should be used for payment of all its debts. But a shareholder personal assets cannot be attached for the debts of a company beyond the amount unpaid on the shares, if any. Suppose I have partly paid shares, 5 rupees payable. 5 rupees only is my limitation of my liability. If I have 100 shares, 5 rupees, 500 rupees, throw it at the face, that's it, my liability over. Company may be having 100 crores, that is not my problem. But company has to pay that entire 100 crore or go for insolvency or what? Are you able to understand? So the liability of a company is always unlimited, but the liability of the member is unlimited. In unlimited liability company, the member's liability is unlimited. Suneji, please understand, unlimited liability company, the member's liability is unlimited. So who will become member of such a company? Yeah, that is better to go for a partnership now without so much company. But still, there have been some companies formed in those days with unlimited liability and all. which are continuing. For that purpose, the new law has given that space for these fellows to come and stay, unlimited companies. Otherwise, nobody will form unlimited company unless certified insane fellow only will do it. Otherwise, why? After all, I can form a company with limited liability. Why I will form unlimited company? I mean, as well form a partnership. Yeah. Why go there? So why they formed unlimited in those days? Seriously, I don't know. Provision is there. That's all. If you want, you can form. Okay. So, of course, it can have capital or it need not have. It's limited by guarantee. I'm sure you've already seen it. I don't want to waste your time. So, before you form a company, remember, you have to decide, first of all, am I going to form a private company or a public company? What is the basic difference of private company and public company? Private company has 3 conditions in its articles. Limits the number of members, restricts the transfer of shares, prohibits any invitation to the public for any shares in or debentures of the company. So, limits the number of members, restricts the transfer of shares, restricts private company, and lastly, prohibits the invitation to the public for any shares. And so, by this, I understand that private company cannot go for IPO. A private company cannot access the public. It cannot make an initial public offer. For to do that, it has to convert itself into a public company. Whereas a public company does not have any of these things. Shares are freely transferable. There is no restriction on the number of share transfer of shares, no limitation. And you can have 1 crore members also. And no, whereas private company, if I write 200 members, can't go beyond, 50 members. Okay. 50 or 200? Check out. I think it's 200. Yeah. So, and 7, but public company, minimum number of persons mentioned below can form a company for the lawful purpose by subscribing their names. So, public company, 7 or more persons. Private company, 2 or more persons. And OPC, 1-person company. The name is a 1-person company. Therefore, only 1. Now, strictly, a company formed under this act should have the minimum number. There should not be any fall below the minimum number. Therefore, the law is very strict on this. And we have a very clear provision to bring about personal liability of the remaining members. So, basic condition, the number of members shall fall below the statutory minimum. That is to say, less than 2 in the case of private and less than 7 in the case of public. What happens for OPC, we will see. When we see OPC, we will see how the law treats that. Because if that 1 person dies, what happens to the OPC? Don't worry. It's not a suspense. We will see that when we come to OPC. Inshallah, we will see 1-person company today. Hopefully, at that time, I will tell you about the situation. As of now, we are in section 3A, we are only concerned with 7 and 2. So, private company falls below 2, public company falls below 7. Right? So, for some reason, death or some incapacity or whatever, the number of members falls below the statutory minimum. Right? Company carries on business for more than 6 months after the number is so reduced. So, on a particular day, the number of members is reduced below 6. It is reduced below 7 or 2. From that date, the law gives you 6 months to rectify. 6 months to increase the number. If within that 6 period, the number is not done, then nothing is done. Okay, then, and the business is carried on for 6 months, more than 6 months, after the number is so reduced, then 6 months over now. The remaining members should be cognizant, aware. Those members who are aware of this and carry on the business beyond 6 months, those remaining members shall be severally liable for the payment of the whole debts of the company contracted during the time it carries on business after 6 months and may be severally sued therefore. When you studied partnership in those days, you would have studied now partners are jointly and severally liable. What does it mean? I am the creditor. Three are there. I can file a suit against any partner. I can file a suit against any partner because the partners are jointly and severally liable. The partners are jointly and severally liable. So, in those cases, any one person can be made to pay the debts incurred after 6 months. So, we have to be very, very careful in understanding this provision. Number of members falls below. Company carries on business with reduced number for more than 6 months. More than 6 months. After the number is so reduced, the remaining members carrying on beyond 6 months will be liable for debts incurred after 6 months. So 6 months is the grace period. Within that, for example, in those days when my father was also practicing CA. So one person came to my father and said, sir, myself, he and his wife are the only shareholders of the company and directors of the company. Unfortunately, the wife died. Now he keeps coming and crying. He's saying, what to do? What to do? Okay. Of course, on the one hand, he is a grieving person. We have to give him moral support and don't worry. And first, we can't quote Bhagavad Gita also, you see. We can't say, Yadasya dhruvam mrityu, dhruvam janmamritasya cha. What to do? Your wife is dead. Don't worry, she'll be born again. Whatever. So the point we are trying to say is that sort of advice definitely many times practicing CAs, not big multinational firm partners, but medium firm partners like me, we also act as family friend. We also act as counseling. We do so many things. In addition to auditing the books of account, we become so close to these people and the clients. Family auditor. They say for the last our firm is 50 years now, and I've been practicing 35. Father, it will say 50 years. All told 60 years. We include my father's period before the firm was founded by him. So all if you take families, 3 generations, so sometimes they come. And so we were telling this. But no, beyond that, he wants also professional advice. What he says, sir, what to do now, sir? Okay, sir, what to do now? What to do? Within 6 months, you marry. I mean, you get one more partner or one more shareholder, and you make them shareholder like that. 6 months is given for that. If even for the 6 months you don't do anything, you sleep, then personal liability will start. Okay. So Amar, Akbar, and Anthony, along with 5 of their friends, were members of Harmony Limited. Amar killed Anthony and Akbar on 18 August 2022. Some fighting between them, maybe, and this guy killed the other. Yes. Okay. What happened? So don't worry about why he killed and all. That is not the point. Hence, the number of members reduced to 6. Amar, Akbar, and Anthony, along with 5 of their friends. So this guy kills Akbar and Anthony, and only now 6. Okay. And the remaining members are aware of it. Am I correct? 5 plus 3. 5 plus 3, 8. Now, Akbar and Anthony mar gaya. Now, Amar with 5 becomes 6. Amar aware, definitely aware. How Amar can say? Amar only killed him. He is well aware. And the other members are also aware because possibly they were all present at the time in the bar when these fellows fought and they killed this fellow killed them. Whatever it is. So, other members also aware. Now, Harmony Limited continued its operation without increasing the number of its members. Right. So, from 18th August, 6 months. Okay. So we can say 17 September, October, November, December, January, February 17th is 6 months over. February 17th, 6 months over. Okay. Now, in March 23, the company took a loan for business purposes and defaulted in repayment thereof. Now, limited liability is gone. Harmony Limited, sorry, because it's below, more than 6 months. Debt was incurred after 6 months. So the lender of the loan can sue the company or Amar or any of the remaining members because they are severally liable for the repayment of the said loan. Right? So I'm surprised to see there are no queries in the query pad. In case you have any queries, can you let me check if any of you has chat. Please do not raise queries in the chat because for me seeing it is very, very difficult. Thank you for wishing me in the chat box. Okay, thank you, thank you. I will have to I will have to look at the chat box frequently. Correct. Anubhav Malik ji says East India Company, yes. Second chapter was, this is the chapter 2, preliminary, then incorporation. I already told you, don't follow with the chapter, you check it later. Incorporation of company, you can't miss it. Huh? Yeah. The chapter name itself is incorporation of company. I don't think. Why take a risk? I'll show you the chapter, then you can see. This is the chapter bus. Can you see? This is the chapter I'm teaching. See it. Okay, this is the chapter I'm teaching. This is the chapter I'll be teaching for the next 3 classes. Don't ask me again, yeah, please, yeah. Incorporation of, this is the chapter heading in the Companies Act also. Companies Act chapter heading also same, chapter 2, incorporation of money, in your SM study material also. This is what I'm teaching. Okay. Clear? Chat. Subhanshi Groverji, please, there's a query pad. Try to access the query pad if you can. Repeat kar do, repeat karenga. Let us see. Okay, one sec. See, what is the third point? See, boss, company, number of members falls below statutory minimum. Company is carrying on business for more than 6 months. So, see, take this example, you will understand. That's why I'm giving the example. 18th August, Amar killed Anthony Nathwar. On 18th August, number falls below. Then 6 months you count. 17th September, October, November, December, January, February. So 6 months ho gaya. Beyond 6 months, what this fellow do? They are running the company with a reduced number. They are running the company with the number is reduced beyond 6 months, more than 6 months. Then the remaining members, who are they? Amar and the 5 other Bakras, no, they who are aware of this and carry on the business beyond 6 months. See, they are aware, no? The members were aware about it. Now, so those fellows, when they do it, that's why we are putting this point, where aware. Then they will become personally liable. This is what it means. This is what it means. Okay. Are you clear? Yeah. I wish you could access the. What is the meaning of ratification? Is asked by Anup Kumar. See, for example, I'll give an example. I am appointing you as an agent, my agent. When I appoint you, I'm giving you a list of things you can do. Maybe I'm asking you to, I have a house in Pune, so I'm asking you to rent it out on my behalf and, give it to somebody for rent at a decent rate. I give you the full freedom. I give you the full freedom to, do this. And so you're my agent. So you locate a good tenant. I even give you the freedom within that band with 25,000 rupees, you're getting, I'm okay. Anything 25 or above, I'm okay. So you are going ahead and getting, you are on my behalf, you enter into that, I give you a power of attorney. Now you are my agent. Now you don't have the power to sell the house. But what happens now? The tenant who is coming, they are a very rich fellow. They give you a price which is extremely good. So since you like me, I am your teacher, you say, sir, I will, without telling me, you sell. You don't have the power to sell, but you enter into an agreement of sale. Now, that agreement of sale is normally not binding on me because the agent has exceeded the limit and gone. But still, after I come talk to you, I shout, then you also say, sir, Suniya ji, see, the price is too good. You go and verify. Then I go verify and I find that the price you fixed is the best price. So thereafter, after the event, I approve it. That is called ratification. When the principal approves a transaction which is beyond the duty of the agent, after the agent has done it, it is called ratification. If you ask my permission, then where ratification? I give permission. Whereas after you have done it, thereafter I accept it. It is called ratification. Are you able to understand? My son loves a girl. I tell him, without telling me, he takes her, gets married her. Then I approve the marriage. That is called ratification. It's not approval. Before he does that, it's permission. He has done it. Now I'm saying yes, I'm happy. You go ahead. Yeah, that is called ratification. Anup Kumarji, I've given you the best explanation I can give on ratification. Anyway, what if I'm saying I'm not aware? You go say, Anubhav, all this and all, don't waste time. Yeah. See, these are in law paper. I'll tell you one thing. Never ask a question about proof. This problem, if it comes in the exam, you cannot question it because it very clearly says remaining members are aware. That's it. Okay. So don't worry. In the examination, whatever facts are given, you work with it. Okay. To answer your question, instead of, I'm not trying to say I will not answer, but to answer your question, I'm saying, Anubhavji, if you say you are not aware, you have to prove it. You understand? If you say you are not aware, in the court, you have to, I am the creditor. No, I will say you are aware. I am averring a fact. So you have to prove it. That you have to prove that I am wrong. I will lead witnesses from the bar itself, and I will say, when Amar killed Anthony and Akbar, this fellow was there. He saw with his own eyes. 2 shareholders are dead. Now, how can he say he is not aware about it? So these are all questions for the court to decide, and lawyers and judges to decide. You and I are ordinary chartered. So let us not bother about proof. If a principle of law you understand, that is enough. Those who are aware will be liable. If you are saying you are not aware, prove it. You are not liable. Okay, that is the best answer I can give you. Sir, my son is an advocate, incidentally. He argues cases in Madras High Court and other lower courts in Chennai and Tamil Nadu. Point is, this type of dispute, only my son is making money. I'm not aware. Proof. So all that lawyers will take care. Don't worry about it. You and I as chartered accountants should be bothered only about, only about the law, the principle of law. Thank you, Anubhav, for confirming that you got it. And thanks for also saying that, okay, example was good. Nice to know that. And okay, going on. So now we come to another important area, steps for incorporation. First step, of course, you have to decide whether you want to form a private company or a public company. Then you have to go for reservation of name, right? See, when I was conceived by my mother, I was not the first child. Before that, they lost a girl. My mother was very worried. She prayed to all the gods in the pantheon. And then the naming also was to be done. So at that time, that was in 1966, 65, I should say, when I was born, I was conceived. There was a movie called Major Chandrakant in Tamil Nadu. I hail from Chennai, a southern part of India. I'm sure you are aware. There's a small state called Tamil Nadu where some of us live. And I come from a small city called Chennai in the south. So there in the southern part, there was a movie released at the time called Major Chandrakant. Now, that movie, there are two characters. One is Srikanth, the other is Rajinikanth. So happens that Major Chandrakant will have two sons. One son will be a wicked fellow, he'll do all nonsense. The guy Srikanth is a police officer. Okay. So my mother and father went for night show. They're coming back in scooter, Lambretta. In those days, my father had a Lambretta scooter coming back. At that time, my mother is telling my father, I will definitely give birth to a son. If so, I want to call him Rajinikanth. But my father is telling, no. He is such a great, very honest and honorable person. He is telling, no. My son should not be named after a wrong person. My son should have the name of the police officer. So only Srikanth. I'm saying all this type of things are there for human names. But for a company, you can't choose a name that you want. See, there are so many Srikanths in India. In fact, in Chennai itself, in Rotary itself, there are 3 Srikants. In Freemasonry, there are 3 Srikants. Confusion. One Srikant will have arrears to enlarge. I will get the bill. The secretary treasurer will call Srikant. You have to pay 800 rupees. What 800? I'm not even a member of your lodge. Yeah. So then who is that Srikant? The other Srikant, not me. So all that confusion happens, but we accept it. But for company, no. Company, if you want a name, first you have to choose the name, and that has to be approved by the registrar. First, the registrar should say this name is available. So that is called reservation of name. Later on, when we see name clause, I will tell you more about it. But basically, you cannot form a company with a name that is identical with or too nearly resembling the name of an existing company. You cannot form a company with a name that is same as the name of another existing company. Because confusion, see in this case, like that, a lot of confusion will happen. Therefore, no. Also, it's quite possible to cheat. Suppose there is a very popular company, okay, which is very good company. Now, if you form another company with the same name, public will think you are part of that group. So they won't give like that. So when we come to name, I'll in more detail. As of now, you understand that if you want to form a company, pehle you have to go for reservation of name. Finish that. Then you have to prepare memorandum of association, MOA, and articles of association. As part of this topic, in detail, we will see the content of memorandum, etc., articles, etc. Don't worry. As of now, these 2 important documents are to be filed to the ROC. ROC means Registrar of Companies. Registrar of Companies. Of Companies. Right? COI, Registrar of Companies. ROC. It's a registrar. Basically like a registrar. You register name. All these documents are to be e-filed and e-stamped. Okay? And the consent of persons nominated as directors should be submitted. So if you're naming A, B, C, then all of them have to give their consent. And that also has to be uploaded. And the statutory declaration should be given that everything has been complied with. This can be given later on, we'll see who can give it. Then some fees will be charged based on the authorized capital. Memorandum and other documents have to be stamped. Everything will be done electronically. Then finally, when all the papers are submitted, the registrar, or I should honestly say the Ministry of Corporate Affairs. Because today, the peculiar role of a registrar, to my knowledge, has lost its significance. Though, for administrative purposes, we have registrars. Okay? For registration of a company, it is all centralized in Noida. And all applications go there and get approved and come back. But it is all done by registrars and their people, but it is done electronically, digitally. Earlier, we used to file the papers with the local jurisdictional registrar and then go there and meet him. They'll give a date for correction. We have to go there. Then they'll go through it and say which are the corrections. And then they will ask us to correct it. Then once you made the correction, we give it back. Then they will issue the certificate of incorporation, physical document. I have to go collect it and come. All this was there. Today, nothing. Once you finish, by email, the certificate of incorporation will come, digitally signed. Okay. And then, within 30 days, you have to locate a registered office and give the declaration about registered office. All this has to be done before a company can be. 6 to 6, you will get a certificate. Then within 30 days from the date of certificate, you have to file certain documents, including details of the address of the registered office of the company, right? Now, since it's online application, they said, let's make it easy. One of the important problems is if you want to become a director of a company, before you become a director, I repeat, before you become a director, you should have DIN, Director Identification Number. So when somebody comes to me for incorporation of company, there are 2 people. I'll ask them, who are all the directors? They'll say A, B, whatever. They'll say, do you have DIN? Are you having DIN? DIN? Kya hai DIN? Then I'll say you have to apply for that. How long that will take, sir? That will take another 1 week plus. You have to apply, get it approved. KYC is there. You have to give me all your, including under size, we'll collect it from you, upload it, then you'll get DIN. Then only we can make application for incorporation, name availability also. So they'll start crying immediately. So in the meantime, our enlightened Prime Minister has given us a wonderful method of doing it. He said SPICE, simplified pro forma for incorporating company electronically. It's a new form, SPICE Plus, form number INC 32. This form is a combined form. Once you make an application in this, up to 3 directors, you can also apply for DIN. You also apply for name. In those days, first you used to apply for name, then get it, then incorporation. Now nothing. Prepare all the documents. Prepare SPICE. If up to 3 directors, give the KYC in the SPICE itself. Upload all this in one shot. You will get your company through. That is why it's called simplified pro forma for incorporating company electronically. INC 32. See these form numbers in company law. As we go through the chapters in future, you will realize it. In most of the cases, the form numbers are basically abbreviation of the chapter. So incorporation is the chapter, incorporation of company and matters related thereto. So they've abbreviated as INC. This is form number 32. So it will be INC 1 onwards, depending on the sequence. This is 32. Okay. So the Ministry of Corporate Affairs has taken various initiatives for ease of business, whatever it is. This is one such. One main advantage is DIN I can apply for 3 straight away. So when a director comes and they say we don't have DIN, we say don't worry. Give us the KYC. Along with the company, you'll get the DIN also. So of course, in sequencing, what they'll do, they'll first allot the DIN, then they will allot the SIN. Today, everything is electronic and digital, sir. When you come to the company law, entire administration of company law is being done digitally. Therefore, you need nothing, no physical meetings, etc., etc. No need also. Most of it is ease of doing business. Much of it is online. No need for any worries. Now, there are 2 ways in which you can file memorandum and articles. One, you can physically prepare the memorandum, get it physically signed by the parties, by the signatories, witness, and scan it, upload it. Or if they have digital signature certificates, then you can prepare it in EMOA in form INC 33, EAOA in form INC 34, and upload that also electronically. Okay. So it should be signed digitally using digital signature certificate. Otherwise, you have to sign physically, name, address, description, occupation, in the presence of at least 1 witness who shall attest the signature. All of them together can be done by 1 witness. Sign and add his name, address, description, occupation. See, I started my practice in technically COP 87, then 3 years with Pricewaterhouse as an audit manager. I was holding my COP. Then 91, 90, almost 90 end, which you can say 90, October or so. Somewhere in 90, I quit Pricewaterhouse and I started my own practice, 1991. So almost 91, you can say, 91, I joined the firm. Karpagam Krishna Natarajan, my firm. 1991, I joined. The official record says 91, Srikanth joined the firm. Okay, firm was founded in 1973. I joined the firm in 1991 as a partner. Point I'm trying to make is, when I started my profession, I used to incorporate a lot of companies. And I used to sign as witness, including some very famous companies. Now it's not very famous, but once upon a time, it was a national brand for HR called Mofa Management Consulting. So I formed it for the promoters, Mr. K. Pandirajan, a great entrepreneur and a great person, highly learned man, who went on to become a minister of the Legislative Assembly, Tamil Nadu. And so very, very dynamic and different. And I had the good fortune to be associated with him for about almost 93 to 2012. It's quite a long time. So the point I'm trying to make is, I used to sign witness. Then one case, what happened, that fellow during that peak, that all that finance company frauds were there, now that Ishwari Benefit Fund, all that came. At that time, one fellow formed one company and took money and he ran away. I formed, see, when they come, I formed the company. I will not become auditor. I used it. I was also a company secretary. So happens I'm a company secretary and a chartered accountant. They used to go there and do it. They'll come and charge a fee for it, do it. Then after incorporating the company, I'll give it. I won't do the auditing. I'll give it to them and go. Thereafter, my name is there in the witness. No, the CBI came and got me. I said, Baba, I only signed as witness. Yeah, how can? Then that CBI officer, he also accepted, sir. We just want to know, since you are a witness, whether you know where they are. I said, I don't know. I gave a sworn statement. I have no connection with that fellow. I don't know where he is. And thereafter, I got a little cautious. I said, no more witness. You bring your own witness and do it. Only for extremely important cases where the promoter requests me personally. Sometimes they request and say, for me, meeting, I advise them, do this, do that. Sakaro, do this, do that. Then I walk away. My people take care. So we have to file these documents. Where subscriber is illiterate, it's quite possible. Even today in India, there are people who are not able to sign, not able to write. Nothing wrong. Never underestimate an illiterate person. Some of the top entrepreneurs are top people in India are illiterate in the sense they can't write their own name. They are worth thousands and thousands of crores. So don't think literacy has some great value. There are engineers who are working as server in hotel, and there are uneducated people who are running that hotel. So, what is literacy? What is illiteracy? I don't know. Anyway, in case he is illiterate, then he shall affix his thumb impression or mark, and somebody will write for him and place the number or name of the subscriber below, and then he will sign as a witness. And everything. Okay. In case you want to typewrite it, you can, so long as some thumb impression is appended. You have to tell that such and such a thing was read out to him and he understood it. Once I have done it for a lady. One lady, she came, her husband, he was not educated. So it was read out to her. At least nobody read it. She signed and said, then she put her thumb, then I wrote there, was read out to her and translated into Hindi, told to her what is the meaning. With understanding, she signed. But the subscriber is a body corporate, memorandum and articles shall be signed by director, officer, or employee of the body corporate, duly authorized in this behalf by a resolution of the board. Very, very important. A company can be a shareholder of another company. For example, we formed wholly owned subsidiaries. I have a client who wants to form a WOS, wholly owned subsidiary, in which case that holding company will be holding 99.9% of the shares. One share will be held by a nominee. One share. That also belongs to the holding company only. But that share will be registered in the name of one other person in order to make that minimum two for that purpose. For that purpose, you'll have one nominee. In which case, the company cannot come and sign now. Company is an artificial person. Just no hand, heart nahi hai. So how can it sign? Therefore, a director, officer, or employee of the company will sign for and on behalf of so-and-so company limited, so-and-so MD, director, CFO, whatever. So long as that person should be authorized by a resolution of the board of directors. Also, that authorized person should not be a subscriber to the memorandum and articles. Okay, means if Mr. A is authorized, he cannot be the other director. They're able to understand? I mean, other shareholder. Okay. So I need somebody totally different to sign other than him. In other words, he cannot sign for ABC Limited A. Then the nominee one shareholder is also A. No, that should be B. In case of LLP, by a partner of the LLP, authorized by resolution, approved by all the partners. This is something very peculiar and funny. Because in company, we always talk about resolution, which means majority. Usually in board meeting, resolution is passed by simple majority. Whereas here they say all the partners of an LLP. Right? Foreign national Foreign national, please understand, there's a big confusion. Many of our brothers and sisters go to US on green card and H1B and all. They think they are US citizen. No, they are Indian only. They are still holding Indian passport. They're talking about foreign national. Okay. The way they start talking, they talk as if they are already they are related to Trump, like that they are talking. Okay. So still they are only Indians. Till such time the US government deems fit to give them their passport in US passport. These gentlemen and ladies are only citizens of India, Indian nationals. So his signatures and address on the memorandum and articles and proof of identity shall be notarized by a notary public with a certificate. This is major problem. The minute, see, I have done it easily. About 50 companies have done where the company is formed by foreigners. See, invariably, a lot of countries, Canada, Finland, Dubai, of course, Abu Dhabi. So many people come to India, they are referred to me. The minute I find that it's a foreigner, immediately I throw up my hands and I say, boss, if you want the company, please be careful. It'll take time. Which country? I said, look here, even if you're going to sign it in India, every proof has to be notarized by a notary public in your country. Okay. And if he is residing in a country outside the Commonwealth or which has not signed the Hague Apostille Convention, then it has to be certificated by a notary public, should be authenticated by a diplomatic or consular office. Means the Indian consul, high consul in that country, he should authenticate it. It's a big job. Okay. And in US, it's apostilling. Now, apostilling, again, you have to go to the Indian embassy or you have to find a suitable apostille. See what happens. First, it is notarized. Okay, the entire documents are notarized. Means there is a lawyer called a notary public that will all go through all the original documents, then sign the Xerox or copies, and he will say original scene, notarized. Then that notary, whether it is valid or not, there will be one more certificate called apostille, by which the diplomatic council, that high council will, our Indian high council will say this notary is valid and his notarization is correct. So that is called apostilling. So much work has to be done. It's very costly. Everything is a fee. So the first thing I tell them, Baba, this is what you want. This is what's going to happen. Minimum 1 month. Go do everything. Send it. I will upload it. Sign it and send it. Then only I can tell you. If you come tomorrow, I want it. Not going to happen. So much work is to be done on this. If a foreign national is to be coming, not difficult, so long as I'm upfront with them. So most foreigners are they are very reasonable. The minute you tell them this is what it is, they agree and they go back and they come back with the documents. They have done it. Easily 50 companies have incorporated with foreign nationals. In many cases, only one subsidiary. In some cases, 2 individuals will be there. And so on. From Singapore, 2 individuals one day, once they came and formed. It happens. Okay. The subscriber to the memorandum is a foreign national residing outside India and has visited India. In such case, he or she is having a valid business visa. Then in case the person is of Indian origin or an overseas citizen of India, the requirement of business visa shall not be applicable. But see, I hope you saw the point. If he is going to sign it abroad, all this nonsense. If he is going to do it in India, no problem. Even then, the proof of identity, etc., should be notarized and sent. But signing, if he's doing here, then the memorandum need not be notarized. Okay. But he should be holding a business visa. But PIO and OCI need not have a business visa. That's all. Again, when you come to OPC, there'll be some confusion about citizen and all that. Never have a doubt about citizen. First of all, it is not possible to be a citizen of 2 countries. Dual citizenship, not possible. India doesn't allow. US doesn't allow. If you want to be a citizen of India, you cannot be a citizen of any other country. If you want to be a citizen of US, you cannot be. Then what is this overseas citizen of India? This is a small card we give to them by which we waive the visa requirement. And they can enter whenever they want, go whenever they want. So they don't have to apply for visa from India. That's all. But otherwise, for example, if a person is holding an Australian passport, she may also have an OCA card. doesn't make her a citizen of India. No way. Yeah. She, being a person of Indian origin and she has got an OCA card, she can walk in whenever she wants. Some small benefits are there. Otherwise, the citizen is different from OCA. Okay. Don't confuse OCA with citizenship. And don't think that that is dual citizenship. I'm not trying to belittle or I'm not trying to make thing, but I want to be factually, we have to be factually clear. Sin, we already saw that. Sin. Am I correct? This is PAP. CIN. Company Identification Number. So sin. So the sin has a code. If you see the sin of Infosys, it's so huge. L means listed. U will be unlisted. So Infosys is listed. Next 5 digits, 85110 is the number. KA, it was registered in Karnataka. 1981, year of incorporation. PLC, public. PTC for private. FTC for foreign. And GOI for government. Last 6 digit registration number with concerned ROC. Okay. So this is the total. Right. Just to give a clarity on sin. Who bothers about all this? But by reading the number, you can get a lot of information, whether it is listed, in which year it was incorporated, whether it's a private company or a public company or what, etc. Now, I told you, a declaration has to be given that all the requirements of this act have been complied with, right? That all the requirements of this act have been complied with. What I may do is once a logical conclusion happens here, I will give a small break and then we can start again. Small break, but not now. Abhi to nahi. Thodi si baat. So, a declaration in form number INC 8 should be given by an advocate, a chartered accountant, cost accountant, company secretary in practice, whoever is engaged in the practice of formation of the company, or by a person named in the articles as director. Okay. No, it is not both. I do not give this declaration. I invariably, when I'm incorporating company, I insist that the director only gives it. One of the person named as the director, you sign. As I told you, once bitten, twice shy. I don't want to get into this business at all. The declaration is that all the requirements of this act and the rules made thereunder in respect of registrations, matters precedent or incidental thereto have been complied with. Then INC 9, from each of the subscribers to the memorandum and from persons named as first directors, that all the documents filed with the register contain information that is correct and complete, true to the best of his knowledge. He is not convicted of any offense in connection with promotion, formation, or arrangement. He has not been found guilty of any fraud or misfeasance or any breach of duty to any company under this act or previous law during the last 5 years, right? And his address for correspondence till the registered office is established. So all this to be given in INC 9. The particulars of names, including surnames or family names, residential address of every subscriber, along with proof of identity. And in the case of a body corporate, the SIN, all that. Also, for directors, the DIN should be given, residential address, nationality. Foreigner can be a director, nothing wrong. Yeah. The particulars of the interests of the persons mentioned in the articles as the first director of the company in other firms or bodies corporate, along with their consent to act as directors. So, any person who is mentioned as first director should, the time of incorporation, give details of interest. For example, in which all companies he is a director or shareholder, in which all firms he is a partner. Is he a proprietor of any proprietary business? Everything. Is he a partner in any LLP? Everything should be given. His interest should be disclosed at the time of incorporation. right? Once all this is over, the registrar of companies will be pleased to issue certificate of incorporation, right? And register the company. Okay. So the registrar, on the basis of documents and information, will register the company and will issue the SIN. And once all this is done, the company shall maintain and preserve all documents and information as originally filed till its dissolution. Till its dissolution. This is a permanent. Okay. Everything should be kept till dissolution. In case somebody gives false information, false or incorrect particulars knowingly or suppressing the material information at the time of incorporation, during incorporation, or the company already incorporated by furnishing false or incorrect information, etc. So there is a company being incorporated. The registrar discovers that you are giving false or incorrect particulars. Company already incorporated. Later, the registrar comes to know that it is false or incorrect. In both the cases, the person furnishing the information or the promoters and persons named as the first directors shall be liable for action for fraud under section 447. Later on, when you study prospectus, either myself or some other faculty will tell you what is 447. Because one of the punishment for criminal liability, okay, for misstatement in prospectus is 447. 447 is a very stiff section, up to 10 lakh penalty, imprisonment, six months, 3 years, all that. Very stiff. Company is incorporated by furnishing false or incorrect information or representation, by suppressing any material fact, or by any fraudulent action. Company is already incorporated. See, suppose it is in the process of being incorporated, no problem. I can stop the process and say, get out and punish these people. Already incorporated, then what to do? Okay, the registrar will take it to the tribunal, and based on that, the tribunal, on an application made to it, will pass suitable orders as it thinks fit for regulation and management of the company in public interest, so that they may appoint some directors and all to control it, whatever, including changes in MOA. That is, the idea is, suppose the people who formed it were bad, but later on the company can be revived and run, then they may do something about it. Or if all of them are fraudulent and they have borrowed money, then they will say, we will ignore the corporate identity. In fact, this is one of the grounds when the corporate wheel will be lifted by tribunal. Are you able to understand? Normally, the separate legal entityship of the company is sacrosanct. So, there's a famous case, Solomon versus Solomon and Company, which you studied, I'm sure, in your CPT or in your school or whatever, college or whatever, where you studied about Solomon versus Solomon and Company. The law refuses to so easily lift the corporate wheel. A company is a separate legal entity. Members can never be made personally liable. One example we saw, when the number falls below, after 6 months, they will become personally liable, right? Similarly, here they say when you are given false particulars and information, and then the members will become unlimited liability. The creditors, instead of suing the company, can also sue each member for whatever he is worth. Okay, there is no limitation on the liability. Okay, the tribunal can direct the removal of the name of the company from the register of companies in case the company has not done anything, still blank, but false furniture have been given. So they can simply have it struck off. They remove it from the name register. That's it. Or they can pass, in case some creditors are there, etc., they can also pass an order for winding up of the company. Such other orders as may deem fit. So many reliefs can be given for company. So the company shall be given a reasonable opportunity of being heard in the matter, and the tribunal shall take into consideration the transactions entered into by the company, including the obligations, if any, contracted or payment of any liability. All that they will consider and pass an order. Now, before we go into commencement of business, let me take up the query, if any, and we can have a small break and then start again. Okay, some of you have, since I said I am from Tamil Nadu, actually, having said that, I identified myself as coming from Tamil Nadu. Please, other states don't get upset. It is just that, see, all of us have to come from some state, no? What do you say? We have to come from some state. It so happens I am from Tamil Nadu. But I have traveled all over the country, ma. There is scarcely any place in this country where I have not traveled. Believe me when I say this. Right from the foothills of the Himalayas to Kanyakumari, right from the extreme end of Nagaland, Mokukchung, Burma border to Wagah border. Okay, in between Madhya Pradesh, Maharashtra, you name it, Uttar Pradesh. Okay, recently I was in Prayagraj for Kumbh, visited Ayodhya 2 times, come regularly to the north. So point is, the entire country is mine. I don't belong to any. That way I consider India. Okay. Sir, 32 is a beautiful form, sir. Okay. So here, some of you are asking for my number. I can't give that. Let's see. We will see. I'm very much there on LinkedIn. You can go and send a message on LinkedIn or Facebook. Sridharan Srikanth, through social media, you can write a comment. See, INC 32, to explain it, is a very, very simple form. It's a combined form. It is a combined form. It's called Spice Plus, wherein it's a form by which you will give details of the directors, name availability you apply, and along with that, you will file memorandum articles, everything, all these documents you file. Then one shot, the company will be incorporated. So this is the ease of operation. That's all. It is called SPICE. SPICE. INC 32 is also known as SPICE. Simplified form of incorporating company. Nothing great about it. If you don't want to use SPICE, there's another method. You can go upload the MOA and all. But then every director should have DIN. But suppose directors do not have DIN, start first time entrepreneur, then this form is very useful. You can apply for DIN also. Name also we apply. In one shot it goes. Okay. So name is approved. Directors are given DIN. Company is, directors are given DIN. Name is approved. Company is incorporated. Take it. Okay. So this is it. No. See, MOA and see, if you go to my suggestion, you just go to MCA and check out. That SPICE form will be there now. Along with that SPICE form, there will be one of the items, in that form will be upload documents. That time you will upload the MOA, AOA, all papers, scanned images you will upload. In case you want to do e-application, you will indicate that. Then automatically the INC 33 and 34 will be uploaded. Okay, they will. Once you say I want to go for e-form, the e-form will be displayed. You will go through it, do all the corrections, then digitally sign it and send it up. But normally what we do is we get it signed and we upload the scanned images. That will be done in the SPICE form itself. There will be a space for that. It will ask you upload form. Then you can keep uploading any paper can be uploaded. Any scanned paper can be uploaded. PDF, you can upload it. That's all. Keep on uploading. At the end of the day, they will do it. Okay. So, thank you. So this is what it is all about. Let us, sort of for about, now the time is 7:25. Let's take a short break for, shall we say, 5 minutes. Hmm? And then 5 to 10, max 10. Let's start again. Sir, small break, sir. So, welcome back. I hope you had a good cup of chai or whatever it is. Let's see what is that one query in the chat. In case of the Kushi Rao, I think the name, maybe she attended an earlier batch. I don't know. Or maybe she's new. Sir, in case of declaration of compliance and subscriber, form authenticating that the information is correct. Please, if see, this is the problem. This thing, if not, see, directors only, if not involving an advocate or see. See, so the point is, there is an option, G. You can either director can give, or yep, actually it's or. Let me do it. This is or. Okay. This is technically or. Because it's either this or that. So either one of these guys or a director. Okay. So idea is somebody should take ownership that all the requirements of this act and the rules are being applied. Based on this declaration only, the ROC is giving the sin, is incorporating the company. This, in fact, this declaration and the signing of the memorandum. Signing of the memorandum is the contractual event. Signing of the memorandum is the contractual event which brings the company into existence legally. But that is completed only after the issue of certificate of incorporation by the registrar, which he does on the basis of the declaration given. So that tomorrow, if there is anything found fraudulent, he will catch hold and ask, hey, you said now, which is one of the reasons why, as a chartered accountant, somehow I prefer not to do it. Maybe I'm wrong, maybe that's not the way to do it. I do not take the risk of signing the thing. Okay. So in case of declaration of complaints of subscriber, the form can be filed, filled, and authenticated by the directors only. Yeah. If in case CA is not there. Yeah, directors. Only directors can do it. A signatory to the memorandum cannot do it. Only a person named as a director can do it. Because tomorrow he'll become personally liable. That means he can be caught now for this prosecution and all that. Okay, now on incorporation, the company comes into existence. So you can go open a bank account, etc. You can acquire GST. Anyway, when you're incorporated, automatically they give you PAN and TAN. They give you automatically, at the time of incorporation, they give you PAN and TAN. Okay. Thereafter, you can even open a bank account. If you apply for GST, they give you GST also, but it takes a little time. So what we do, we incorporate the company, get PAN, TAN, then open a bank account, then go for lease agreement, etc. Then go to GST, get GST registration. All this will take about 1 month. During this 1 month, before the end of 30 days, I have to file certain documents and obtain commencement of business. If the company does not obtain the commencement of business within 30 days, it can be removed from the register. Any company. Therefore, this is a very important post-incorporation activity. Many promoters do not know this. I'm making a point not to hurt, but to make a point that many professionals, especially other than CA professionals, what they do is they incorporate the company and give it to them. Thereafter, they forget to inform them that commencement of business is there. And this has to be done within 30 days. And if it is not done within 30 days, out. So, a declaration is filed by the directors within a period of 180 days of the date of incorporation of the company with the registrar that every subscriber to the memorandum has paid the value of the shares agreed to be taken by him on the date of making of such declaration. Also, within 30 days, the registrar should give a verification of its registered office within 30 days. So, only after you give this, you will be allowed to, in fact, I'm removing this because, see, this was always there. So I was thinking, So within 6 months, the signatory to the memorandum, therein when you come to the memorandum, you will see that in the memorandum, there are various clauses. Finally, you have association clause in which they will sign their name and mention the number of shares. The money for those shares has to be brought into the bank account. So you open the bank account and bring in the money within 180 days. Also, you have to file the registered office details within 30 days. If you don't file within 30 days, the registered office details, company can be struck off. Okay. So you have to give the declaration, then you will get commencement. So that the flag will be removed. They'll say commenced. Only then the company will be, the bank will allow you to operate the account. Unless you produce certificate of commencement, the bank will not allow you to commence. In addition to that, in case you do not comply with the provisions relating to commencement of business, there is a penalty of 50,000 rupees. And every officer, especially every officer means director, who is in default, penalty of 1,000 rupees for every day during which the default continues. Okay. So this is commencement of business. Please remember that. Okay. Now, we move on to another important topic, OPC, one person company. Now, just a bit of statistics in before pre-corona, or rather immediately after corona statistics. There were about 35,000, 34,000 and odd OPCs in India, and there were about 1.3 million, that is 13 lakh companies in 2020. Now I'm sure it has gone up. I'm sure the number of companies has gone up, number of OPCs has gone up. So basically, about 3% of the companies are OPC. Go figure whether that's an important number or. But 3% of the companies incorporated are OPC. In fact, I would bet that majority or maximum number of companies are private companies. With public companies, of course, cream of the cream will be there who have gone IPO, non-IPO, and unlisted public company, etc., etc. Private companies will be majority, clustering. Out of that, small companies will be cluster. Okay. The rest of it would be large and non-small, private, non-small public, listed public, unlisted public, etc., etc., etc. I'm sure you already understood what is a small company, okay, based on the turnover and the paid up capital network. So OPC means a company which has only one person. You already saw this in preliminary topic, I'm sure. Means a company which has only one person as a member, right? So the memorandum of association of an OPC, you're going to see the memorandum. I'm going to show you that memorandum clause in the next class when I will show you how the OPC clause will be there. That clause should clearly indicate the name of the person who is the member, and also it should indicate the name of another person who shall, in the event of the subscriber's death or his incapacity, become the member of the company. Now, this answers your question. No, sir, if there is an OPC and that fellow dies, what happens? Immediately the nominee will become the member. So there will be no situation when the OPC will be without a member. Which is why they say you have to not only sign, but you should also name one other person who shall, in the event of the subscriber's death or his incapacity, become the member of the company. The prior written consent of such person should be obtained in INC 3 and should be filed along with the ROC, okay, at the time of incorporation of the OPC, along with MOA and MOA. This for OPC, very important. Nominee. Very, very important from exam point of view. Please remember. Please try to remember this. A lot of people have raised in the query pad also. Let us see. Okay, we'll do one thing. I'll take it up in the last 5 minutes. Just very, very big. So I will take it up. I'll finish OPC and then I'll take it up. So if you have any OPC questions also, you put it. Okay. So very important. The member of an OPC should be a natural person who is an Indian citizen, whether resident in India or otherwise. See, he may not have to be. See, I don't know why they put this condition. I'm sorry to use that word. What benefit? I don't know. They can simply say should be a natural person who is an Indian citizen. Right. Whether resident in India or otherwise, why? If he's anyway, you are saying he need not be a resident. Why bring that? And they also define residence means a person who has stayed in India for a period of not less than 120 days. Even if he does not stay in India for a period of not less than 120 days, he is still, if he is a citizen of India, he can be a member or a nominee in a OPC. I'm repeating, Mr. A has not stayed in India for, he has stayed in India for less than 120 days. He is a citizen of India. Can he be a member of OPC? He can. Can he be a nominee? He can. Are you able to understand? So why this condition is prescribed, why they bring residence at all, I don't understand. Okay. So if you're going to ask me a question, I can't answer. So I can answer it in a different way. Mr. A did not stay in India for 120 days, but he is a citizen and he is a natural person and a citizen of India holding Indian passport. Can he be a member of an OPC? He can in India. Can he be a nominee of an OPC in India? He can. That's all. Answer. Okay. Why this prescription is there? God only. God and the gentleman or lady who wrote it only knows. Otherwise, no. Why this is there? Nobody knows. And why give a separate definition for residents which are not going to use anyway? God only knows. Okay. So, somebody is giving me some information, I hope, on this. Okay. Thank you, Bhumika ji. And I faced all questions which are mentioned very important. Is that a good thing or a bad thing? Okay. I assume that it is, you are informing me that what all I covered as important were there in the exam. Yeah, see, there are, believe me, boss, it's actually very easy to clear this paper. If you read the entire material from top to bottom, you are in trouble. That is why classes like mine will be useful to you, not to know the subject itself, because some of you may be expert in the subject, but to tell you which is important, which is not important. So you are a type of person who reads the entire material and, sir, you have not covered page 53, paragraph 5, sir. Gone. You are out. Don't even waste your time, my time. I will cover it, don't worry. But may not be of importance from the exam point of view. So important, for example, this is 200% important. If you remember this one question in the exam, you can answer easily. Natural person should be an Indian citizen. That's all. Okay. I'll be uploading some assignment also. In that assignment also, you will see some important questions. So, the nominee may withdraw his consent, okay, by giving notice in writing to the sole member and to the OPC. Then the sole member should nominate another person as nominee within 15 days of the receipt of notice. And that sole member should send an intimation to the company together with written consent of such nominee in form number INC 3. So that INC 3 is for nomination. So fresh nominee, fresh one more INC 3. If suppose the member of the OPC, he doesn't like, as usual, they went to the bar, had a fight. So you are not important, man. Get out of my life. That's it. So not only get out of my life, get out of my OPC also. So he is no longer nominee. So the name of the nominee can be changed, including death or incapacity of such nominee by giving notice. So the sole member should send an intimation of the nomination in writing to the company. So, but of course, you cannot remove. You have to appoint somebody else, right? You have to appoint somebody else. And so, A is a Indian citizen staying in Philadelphia, and he's going study with Indian girl, okay, Sheila. And so he forms an OPC in India for a startup. And he says, Sheila, you are my life. You are the nominee. In case I die, no, don't even talk like that. No. If I die, don't worry. You will be the nominee. 15 days later, this fellow says, no. Leela will become my nominee. No problem. Okay. Whatever it is, you name and send an intimation of the nomination to the company. How he will send to the company? By mail. I don't know what will happen, but he'll do it. He himself has to send it to himself only, because what is that? And then with the written consent of such new nominee. So he has to get Leela's signature. Form INC 3, go. Sheila out, Leela in. Okay, that is your choice. Yeah, you are the member. Do whatever you want. Okay. Any such change in the name of the person shall not be deemed to be an alteration of the memorandum. Because in the original memorandum, Sheila would have been written as nominee. In the first memorandum, nominee's name will be mentioned now. In the memorandum, the first nominee's name will be mentioned now. Thereafter, new nominee, I can't go and amend the memorandum, boss. It is enough if I file INC3, that is enough. Okay. See, some of these examples I am giving are human examples. Don't take it seriously or don't take it, don't be a typical CA, always serious. Sometimes life is humorous and it happens now. Sheila can go, Leela can come. It is part of life. If you think it is not, then welcome to life. So where the sole member ceases to be a member due to death or incapacity, incapacity could be mental incapacity or physical incapacity. Okay. So the nominee shall become the new member. Now, once the nominee becomes the new member, such nominee should nominate within 15 days another person. Are you able to understand? So this goes on and on till time with us shall be no more. So nominee, then suppose the nominee also dies, what happens? Then that new nominee, he will become member, and so on and so forth. In all the above cases, the company should, within 30 days of receipt of intimation of withdrawal of consent, change of nominee, cessation, should file the information with the ROC in INC 4, along with the prior consent of the nominee. Okay. All the notices and intimations shall be in writing, whether a specific form has been prescribed or not. You just take a piece of paper and write and send. Okay. See, once you put your query on the query pad, no, I'll be able to see it. Don't think that I'm not seeing it. It is just that some of you are putting in chat, some of you are putting in query pad. It becomes a real challenge. So if either all of you confirm and don't go to chat, then I'll keep on looking at query pad. Then query pad, I will answer. Okay. Now, a natural person shall, very important, very, very important. Okay, very, very important. More than one OPC, you cannot be a member. And you cannot be a nominee of more than one OPC. So see, suppose nominee is already a member of one OPC. Member in OPC becomes member in another company by virtue of his being a nominee in that OPC. So are you able to understand? Maybe Leela has her own OPC. She also becomes nominee in Vinod's OPC. Now, later on, Vinod becomes mentally incapacitated. Some reason, going mad. Because of Sheila's curse, he goes mad. Now, Leela will become the member. She's already having her own OPC. Now, she can't be a member in two OPC. Such person shall meet eligible criteria within a period of 180 days. She has to choose. Should I be in Vinod's OPC as a member or my own OPC? In which case, she should nominate some as a member and she should move away. So, got it? No minor shall become member or nominee of the OPC or can hold share with beneficiary interest. Okay? Minor, no. See, the purpose of OPC is very simple, boss. You want to start a company with limited liability. You don't want any hassles. You are a creative person. You want to start up. You want a startup. And later on, you want to take it public and all, funding. But before that, you want to have some peace of mind. So for that, OPC is there in other countries. It was not there in India. This gap has been today filled. But if you want to have IPO, see, OPC is basically a private company. Are you able to understand? Also, OPC cannot be converted into a non-profit company. Section 8, we'll be seeing it immediately after this. So Section 8 company, you cannot form. That is, OPC cannot be converted into a Section 8 company. Believe me, this happens very, very frequently. And mostly these OPCs are formed by fellows who go to US. They keep coming, Mr. Srikanth, I want to form an OPC. Why? I want to do service to society. Sorry, you cannot form an OPC. You cannot become converted into a Section 8 company. Okay? But it can be converted into a private or public company in certain cases, provided that company cannot carry out NBFC or investment activities, including investment in securities of any corporate. Conversion into private and public possible. OPC can be converted. Earlier, there was a time limit before which it cannot be communicated, and also limits, etc. All this has been removed. This sub-rule has been removed. Okay. So now any time, any OPC can convert itself into any kind of company. So the 2 years and all is not there. Okay. No need for all that is not there. Okay. Procedure for conversion of OPC into a public company other than a company registered under Section 8. Very, very important. Section 8 not possible. Okay. Because many of these guys who go to US, no, suddenly they'll become very socially aware. They want to do so many things, Okay. So then they'll say, I want to do this. Sorry, sir, you cannot convert into a Section 8 company. Okay. The OPC shall alter its MOA, AOA by passing a resolution in accordance with subsection 3 of Section 122 to give, that is basically a special resolution, to the effect to the conversion and to make necessary changes incidental thereto. So basically the one person should decide, I want to convert into a public company. Then obviously one person cannot become public. So the minimum number of members and directors shall be increased. So minimum number of members for a public company is 7. And minimum number of directors is 2. Okay, whatever. If it's private company, 3 directors, 7 members. Correct? If it's a private company, 2 members, 2 directors. You convert. Then the minimum paid up capital requirement, if any, shall be maintained. Under the old law, there was a minimum paid up capital for private company, which was 1 lakh. Public company, 5 lakhs. Now that minimum paid up capital requirement condition is there, but the government has not prescribed. There is a condition, government can prescribe minimum, they have not done. So as of now, this is not there, but it could come. The government suddenly one fine morning, they wake up, we'll do some nonsense today. What nonsense I can do? Okay, prescribe minimum paid up capital. Go on, do it. So if they do that, then it will come. Okay. Then once you've done all this, you have to apply in Form INC 6 for conversion. You have to alter the MOA, AOA fully, including, you have to include all the things and all and change it. A copy of the resolution passed. Okay. And the list of proposed members and directors, obviously KYC. List of creditors in case the OPC has already acquired debts. And the latest audited balance sheet and P&L account. Latest. So you have to be, whatever is the latest, you have to give. Now, on being satisfied that the requirements stated have been complied with, ROC will issue the fresh certificate. So OPC can be converted into a public company or a private company as the case may be. It can be converted into a private or public as the case may be. Right? That is why here you are taking 2 or 7, 2 or 3. In the case of private, 2 members is enough. Public, 7 members. By private company, minimum number of directors is 2. For public, minimum number of directors is 3. Okay. Now, you can convert a private company into OPC. Okay. Private company into OPC. So that private company should pass a special resolution. Then, before passing, should obtain an NOC from members and creditors. All the members should give NOC creditors. And then a resolution should be passed for conversion. Okay. Then a copy of the special resolution should be filed with the ROC within 30 days in form number MGT14. Friends, form number MGT14, you will come across it when you come to management and administration. Whenever you pass a special resolution, within 30 days, you have to file MGT14. Management and administration, MGT14. That is as part of management and administration. But that has to be filed. Then again, you have to file the INC, reverse INC 6. The same INC 6, but this time, private company is becoming OPC. You might ask me, why can't public company become? No, because OPC is basically a private company. OPC, the name of the OPC will have private company OPC. So, whatever, above private company OPC. Public company, OPC cannot be a public company. Public company, first you should become private and then go for OPC. So you have to file a declaration that all members and creditors are given consent, list of members and list of creditors, latest audited, and a copy of the NOC, letter of secured creditors. Everything should be given. Right? And then, on being satisfied, convert. So, OPC can become private, private can become OPC. OPC can become public, but public cannot become OPC. Clear? OPC is not required to prepare cash flow statement. Annual return, when you come to management and administration, you'll see section 92 can be signed by one director and not company secretary. Okay. And for OPCs, an abridged annual return may be prescribed, not yet prescribed. Similarly, section 134, one director may sign audited financial statements. Also, abridged director's report possibility is there. Because after all, I am the only shareholder, only director. What report I am giving to whom I am giving here? Certain specific provisions relating to general meetings and all, when you come to management and administration, 100 to 111, either I or some other faculty will teach you about those exemptions. There is a relaxation with respect to convening of board meetings. OPC can hold one in each half of a calendar year. 120 days you can have gap. One meeting in each half, only 2 meetings, one in each half of a calendar year. Under section 137, OPCs are allowed to file financial statements within 6 months from the close of the financial year as against 30 days. So you got 6 months. Okay. So all this 137, 92, and these all you get come across in management and administration. There, these relaxations are there. Right? So before I get into section 8, which is pretty lengthy, let me find out what all the questions asked and whether they're good. Why Vishnu Kumar is asking why private company is not allowed to issue? Because the idea of a private company is small operations for maybe a family-owned business or a small group of well-known people. Idea is not to access larger group of people for funding. So that is why private companies, from time immemorial, sir. If you keep on asking me, only reply I can say is, idea is it's a small company. If at all it wants to access public fund, it has to convert itself into a public company. I'll tell you, in those days, private companies had a lot of relaxations. So they wanted to restrict it to people who don't go to the public. So these relaxations are there. For example, private company could give in those days, private company could give a loan to a director without any problem, or a firm in which director is a partner. There was no restriction. Private company enjoy. You can go naked. Okay. But now, private companies are also subject to stringent regulations. So today I don't really see, but still they feel if you want to be a private company, then sorry, you cannot access public. Sir, I have given you an answer. If I'm not satisfied, I'm sorry, but that is the answer. Okay, then compulsory to get certificate authenticated. Yeah, see, if you are an Indian, since you are an Indian company, we need to get it from the embassy. But suppose we don't have an embassy there, then you can go to somebody else. But if you see, usually you will have to approach the Ministry of Foreign Affairs. They will guide you whether there's an embassy there. If not, who will sign like that? You have to go there. I don't know what you mean by WhatsApp link. I'm not aware of what it is. WhatsApp link. Kindly talk to the thing. See, any query relating to connectivity or not getting voice, not getting something, please address it to the help desk or somebody from the Board of Studies. Then the faculty, I only teach. After finding in fraud due to false information from ROC, CA, definitely, if I have signed the declaration, I'm definitely liable. That is why I'm not signing. Okay. But if I have not signed it, sorry, boss, he gave me the information, I uploaded it. He have not certified it, but he certified it, catch. Who can approach tribunal for the good question? ROC only will apply. The ROC, the Registrar of Companies or the Regional Director will apply. If company is filing false information spice so long with the company CA, CSMA, yeah, because they're involved in incorporation to the condition that they know this false. Okay, whatever you mean, the CA is liable, okay. And you have repeated that question 3 times. Please don't do that 4 times. Please don't, 5 times. Don't do that. Don't keep on uploading. Okay. Same question, don't upload it again and again. If you do it once, it's enough. Madam, I am not aware of the WhatsApp group link. Seriously, I don't know. Kindly help me. I don't know. Mujhe nahi malum. Kindly contact somebody who knows.
Yes, students, there is a Good evening, sir.
Yeah, good evening, ma. Kindly clarify that WhatsApp, ma.
Yes, sir. Yes, sir. I will just put it in the chat, and then the students can take it further from there.
Yes, yes. Thank you, madam. Thank you, madam.
Okay, sir.
Nishaji? Yeah, thank you, thank you. So students, I think that is clarified for you. I'm so happy. So moving on, and I think what I suggest, no, you put it in these type of queries, you put it in chat so that institute faculty is also very much available here with us. So she will help us in all these things. Don't worry about that. Okay. In fact, at the outset, let me express my warm sense of appreciation of the people who are run in Board of Studies, the staff and the faculty who are doing a wonderful job of compiling the material, running these classes for you, which is really, I appreciate, not just as a faculty, as a member of the institute, I would like to appreciate them for what they are doing. Fantastic. So now moving on to the next topic, maybe we can cover it or not, it is okay. But we will see. Section 8. Formation of companies with charitable objects. Friends, if you want to run a charitable organization, best way to do it is trust. Form a trust. Okay? But trust is registered under the state trust law. Each under the Indian Trust Act, it is registered with the state government. So I got it. But you can have branches. And see, for example, we have a lot of NGO clients, non-governmental organization, or more appropriately speaking, non-profit organization, NPO. So we have a lot of NPO audits. In fact, I told you, I went all the way to Mokupchang in Nagaland. Okay. Beyond Woka district. It's quite very much east of east. You have to go. Why I went all the way to Kohima was for an audit of a non-governmental organization, which was eradication of AIDS. That was long ago, 15 years ago, more than that. It was when I went to Nagaland, AIDS was very much there. Today, thanks to the work done by this NGO, Indian Network for People Living with HIV/AIDS, INP Plus as we called it, actually AIDS was eradicated. And the purpose for which the company was born, that organization was formed, has come to an end. In my own, for the last 15 years, I've seen an organization formed for a purpose resolved. No more AIDS awareness has been created. AIDS is no longer the pandemic it was. Not that it has gone away, but people are protecting themselves. To an extent, innocent people have been saved. Now only the second generation of the people who have AIDS, they are there. They are being rehabilitated very well. Okay. Point I'm trying to say is such organizations can be formed as a trust or as a society. Again, if you are a society, you will be registered under Maharashtra Society Act, Tamil Nadu Society Act, or whichever. So you will have restricted operation in this INP Plus was a society. They had branches all over India where you used to go and audit, but they are operating from Chennai. Now, if you want to have a pan-India presence, then you are advised to form a Section 8 company under the Companies Act. It's a central act. Therefore, you will be able to operate pan-India. This is the concept. Even then, you will have a one domicile. You will have one state in which you are registered, but you can, pan-India operation can be done if you are a Section 8 company. But forming a Section 8 company is not easy. You have to satisfy the RD, the regional director, that these are all there. You have to satisfy him. You want to get registered under this act as a limited company for the object of promoting commerce. For example, chambers of commerce are section 25. See, in the good old days in 56 law, under the 1956 law, the same section was called section 25. So some of us remember them as section 25 company. Okay. So commerce, art, science, sports, education, okay, research. I think IIT, I know IIT is formed by government. Education, research, social welfare, okay, etc. Charity, all that. It can be anything. Social welfare is wide enough. For example, the club where I belong in Chennai, the Presidency Club, is an old Section 25 company formed under the Companies Act. Most clubs in Chennai are Section 25 companies. Okay. So the point I'm trying to make is, even religion, it should have a promotion of one of these. And whatever profit it makes, surplus, it intends to apply its profits, if any, or other income in the promotion of its objects only. No dividend will be paid to its members. Intends to prohibit payment of any dividend to its members. Once the ROC is satisfied, he may grant a license. Application is made to the ROC, but believe me, it goes to the RD. Stiff. I have done it. I have done it 2 or 3 times. Totally, I have done only 3 Section 25 companies. One was a Chamber of Commerce. The point is, the RD is very tough. They don't permit you to form a Section. Means, friends, you don't form a Section 8 company. You form a company and then obtain a license. You obtain a license to dispense with the words. To dispense with the words private, limited, or public, as limited or private limited, as the case may be. So, you form a company, okay? At the time of incorporation, you also make an application to the registrar for license, for dispensing with the word limited. So, thereafter, your name, you need not have the word private limited or limited, as the case may be. As you are well aware, public limited companies have only limited. So, Reliance Industries Limited is a public company. Okay. ABC Industries Private Limited is a private company. So, private limited will have the word private. Public will not have public limited. It will have only limited. So, okay. The memorandum and articles of association of the proposed company in INC 13 and INC 31. Okay. For these companies. INC 13, and INC 31 respectively. An estimate of the future annual income and expenditure of the company for next 3 years, specifying the sources of the income, a declaration by an advocate, chartered accountant, etc. in Form INC 4 and by each of the persons making an application in INC 15. Here both chartered accountant has to give and also person making the application should be. The memorandum and articles of association have been drawn up in conformity with the provisions of Section 8. All the requirements of the Act and the rules have been complied with. So this has to be given. A company registered under this section shall not alter the provisions of its memorandum or articles except with the previous approval of the central government. Any amendment, before you do it, you have to get approval from the central government. Central government here, see the word central government, wherever you find it, you have to be very careful. Central government is not one body. Central government is different hierarchies in that ministry. The ministry has many hierarchies, of which the registrar is at the bottom level, one of the near bottom. Higher levels are there in Delhi, under secretaries are there, deputy secretaries are there. They are all big. Directors are there. Okay, director DGs are there. So one of the intermediaries is called the regional director, RD. Regional director. Now, there are, as you know, there are 5 regions. So the 4 directions and central region. Now each region, there will be a regional director. So the regional director for South sits in Chennai. Okay, he controls southern states, the 5 southern states: Telangana, Andhra Pradesh, Tamil Nadu, Kerala, Karnataka, Pondicherry, Union Territory of Pondicherry. He controls it together, one RD. Under him, every state will have ROC. Each ROC will come under him. Tamil Nadu alone has 2 ROCs, one sitting in Chennai and the other sitting in Coimbatore. Right. Together, they will all come under the RD of Southern Region Line. That gentleman has to approve. Also, even this license, the ROC will put up the paper to the RD only. And the RD only will sanction, the ROC will issue the license. Internally, it has to go up and come. So the ROC will simply say, boss, I have put up the file to the RD, you go and meet him. So you have to go and meet him, okay. I don't think I can cover this today. I'll just go see where we can go and stop. Special resolution in general meeting for approving the conversion. If you want to convert from Section 8 to any other company, then an application in Form INC 18 to be filed with the regional director along with notice, reasons, etc. and a certificate. We are trying to do that for one of the companies. For one of the Section 8 companies, we are doing this reconversion into a normal company. See, for some time you might decide, I don't want to be anymore. So you file and you come back. Then you have to file a notice in Form INC 19 within a week from the date of submitting the application in 2 newspapers. Why? So because all along the public have been thinking that you are a non-profit. Now onwards, you're going to become profitable, profit-oriented. So that has to be informed. The format is given in INC 19. It has to be published by the company at its own expense in one vernacular newspaper and also English. Okay, on the website of the company, etc. Also, you have to get NOC from all these people: Chief Commissioner of Income Tax, ITU having jurisdiction, Charity Commissioner, if any. In some states, there is no Charity Commissioner. In Maharashtra, there is a Charity Commissioner who is in charge of all public trustee. That gentleman, Chief Secretary of the state in which the registered office of the company is situated, any organization or department under whose jurisdiction the company has been operating. It's not a joke. In case they make representations tardy within 60 days of, then they have to be heard. In case the company has obtained any special status or privilege, etc., that has to be surrendered. Okay, then that authority will not give NOC otherwise. For example, if you are a stock exchange, then you have to get approval under the Securities Contract Regulation Act. A stock exchange may be a Section 8 company, in which case you want to become a normal company, but that can be done. So for example, even NSC is not a non-profit company; it's a profit company. Regional director on satisfaction shall issue an order approving conversion into any other company. Right. The company shall give up and shall not claim any special status, exemption, etc. If it has acquired any immovable property free of cost or at a concession from the government, it has to pay the difference between the cost at which it was acquired and the market price to the government. All the benefits are with any accumulated profit or unutilized income should be done to settle all outstanding statutory dues, lenders, etc. Any loans advanced by promoters and all. Balance should be transferred to the Investor Education and Protection Fund. You cannot take it home. Whatever surplus is there goes to the IEPF. Then clean slate. Take the company, go to whatever you want. The company should have filed all its financial statements and annual returns, etc. Okay. So, on receipt of the documents, the registrar shall register and issue a fresh certificate of incorporation. That's it. Right. In case the central government feels that the company has contravened any requirement, etc., then the central government can revoke the license and the word private limited or limited will be, of course, the notice should be given, an opportunity should be given to be heard. Okay. Where a license is revoked, the central government direct that the company be wound up. See, when the company is doing something very, very bad, using the cloak of this. Okay. Where a license is revoked and the central government is satisfied, that is essential in the public interest, that company should be amalgamated, they can pass an order. Contrary, notwithstanding anything to the contrary contained in this act, the central government can, because there is one whole chapter on amalgamation. So they are saying, irrespective of that, by this order, the central government can pass an order. Because there, you have to go to tribunal, etc. Under Section 8, when they are doing it, the central government has the power to pass the order of amalgamation. Right? So these are all consequential matters, not very important. Some benefits for the Section 25, Section 8 companies are, it can call its general meeting by giving 14 days notice. The minimum number of directors, independent directors, doesn't apply. It need not constitute nomination committee, all that. A firm may be a member of a company registered as Section 8. Normally, a firm has no separate legal entity. It cannot be a member of a company. But if company registered as 8, a firm may be a member. It's because, see, many stock exchanges have firms as members. So they are Section 25 companies of those days. So they are allowed to have a firm as a member. Okay. If a company makes any default, the company, without prejudice to any other section, be punishable with a fine of 10 lakh to 1 crore. Okay. Punishment by imprisonment has been removed. Directors shall be punishable with fine 25,000 to 25 lakhs. There was earlier imprisonment that has been removed in 2020. as part of the decriminalization of the Companies Act. Okay. So with this, we have completed section 8. We have made very good progress, if I may be permitted to say so. Let us hope. So there are no more questions in the query pad, I hope. Once again. Let's see if anything is there in the chat box. If not, I'll close. If you have any more questions, we can always ask. One member, so why board meetings? See, certain decisions are to be taken at a meeting of the board. So there is no prohibition under the Companies Act for one-man meeting. Please don't think. So officially, how do we know a decision has been taken by the company? So for that, there should be a board meeting or a general meeting. And that resolution has to be filed. So see, it is, though I am an individual, on behalf of the company, that decision is taken now. That has to be documented now. For that, we will have a book meeting and we will set it. So, thank you. Thank you. My sections need not be by heart. Even if you don't remember section, chod dijiye, please. No problem. Remember the content, if you are able to remember section, good. Otherwise, don't. Thank you very much for your kind words, Mr. Rajveer. And see, it can have many directors, as you rightly say. But usually we'll have only one. This guy also will become the director. But if you want, you can have more. OPC can have more. You're right. Very intuitively, you're told. Smriti, thank you. Good point. Excellent. Let's hope, inshallah, we'll meet on 12th when we will continue our discussions on company law. Thank you for your kind. Sir, class over, sir. Yeah. Thank you, madam. See you. Bye. Thank you, madam.